Welcome to Litigation Psychology Podcast, brought to you by Courtroom Sciences. As you can see here behind me, I am not in the studio today. I'm actually on the road getting ready to go to a witness training here in beautiful Denver. I'm looking out, I can see the mountains, got a perfect view. But I'm not going to head out until I talk to this gentleman who I have on with me today. I have Jim Feeney from Dykama in Detroit. Jim, how are you?
Fine, Steve. How are you?
I'm excellent. You know, and being a Michigan born and raised, I mean, obviously Dykama has a very good reputation for being, a top tier law firm. But actually how I came to know about you actually was a little bit different, right? CBN published their top 10 most impressive defense verdicts of 2021. And it just so happened that it was a case you worked on, right? It's the Perry versus the Kia Motors, correct?
Correct. And that was in Orange County, California. And I do a lot of work in California. So,
and for those people who don't know about the case, can you kind of give us the 30,000 foot view of what the case was about?
Sure. So there are two ways to do this. Let me start with the basic defect claim. The case was about an injury, a very serious brain injury that had occurred to the plaintiff, who was a 21-year-old woman, a young woman named Kamaya Perry. She received the injury in an automobile accident. She blamed it on the restraint system, the seatbelt system, the airbag system. Basically, they said that the experts that were hired said that the restraint system did not perform the way it was intended to perform, wasn't designed properly, and she received a very serious brain injury. The accident that produced this injury, which she experienced this injury, was an accident that occurred in Southern California about 2 years ago, in April of 2019, or I guess 3 years now. Her brother was driving the vehicle. The brother was 17. He tried to make a U-turn in a divided highway from lane number 2, so the middle lane. He didn't realize or wasn't aware of the fact that a car was coming up behind him on the outside in the number 1 lane. And so as he made the left U-turn, the car hit him in the side. So there was a pretty serious side impact followed by a half-turn roll. So there was a side impact followed by a rollover. He was uninjured. The driver was uninjured. His sister was the plaintiff, and she received this brain injury as a right front seat passenger. Those were the basic facts of the accident.
And the case is currently on appeal, correct?
Correct.
Okay. So, I want to ask you some questions about it, but obviously I want to be mindful of that fact and not dig too deep. But, I definitely want to, especially get for our listeners to understand kind of, praise these defense verdicts and then also dig deeper into them and find out what it is that you did that was successful. So really my first question was, what was your approach in this case? Meaning, when you looked at it, what was really the main points that you felt like you really had to deliver and get the jurors to understand?
Well, it was a very interesting case. And I'm sure, Steve, in your work, you've seen this on more than a few occasions where you're dealing with an automotive product liability case. But you had the driver in this case, the 17-year-old driver who actually caused the accident and was closer to the impact that occurred here. He had a seatbelt whose pretensioner, and we can talk about what a pretensioner is, worked, fired, so snugged him into the seat, and he had his driver's side airbags, which deployed in this accident. And he walked away from the accident without a scratch. His sister, who was farther away from the impact at the time of the impact, had a seatbelt whose pretensioner did not deploy, didn't work. And of course, none of the airbags, because of her position, deployed. She winds up with a very serious brain injury. So from our perspective, it was pretty clear to us that the plaintiff was going to present this as a way of essentially saying, brother was fine. He had a much more severe impact. She came out very badly injured. What's the difference? And the difference, they would say, was the difference in the performance of the restraint system. And that we felt confident that that was the way they were going to present it. So our job was to try to understand that and diffuse that and explain to the jury from the beginning that just because she was seriously injured and her system performed differently than his didn't mean that the system was defective. That was point number one. And point number two, part and parcel of that, was to really explain in a very simple way how she actually received the injury, because we had a side impact followed by a rollover, a lot going on inside that vehicle. So there's a lot of testimony and a lot of expert disagreement as to what actually happened inside that vehicle to produce her injury. Those were the two big issues, big picture issues that we knew we had to address in a way that was consistent and persuasive for the jury.
So, you know, a lot of times on these big types of cases, right, we get called in to do either focus groups or mock trials or any of that. Did you guys do any sort of pretrial research on this case at all?
Yes.
Okay. And what did you learn from that research that you were able to actually use as you went forward in trial?
Well, I don't need to tell you that, to me, I mean, I do mock trial works all the time. And to me, what I get out of it typically is what resonates, what themes can you develop? Can you present themes in a way that jurors can understand them? When you watch the deliberations afterwards, are they actually articulating the arguments you made? Are jurors there using your points in a way that is favorable to you? Now, the worst outcome would be that they fully understood your arguments and they're going the other way in the deliberations, right? That's probably the worst of all the days. But in our case, what we tried to do, knowing what we knew is to be the big issues in the case, what we tried to do was we experimented with different ways to present the complexity of the accident as well as the complexity of the design system. So we used different exhibits, we used snippets of testimony, we used articles. We tried a lot of different combinations of evidence that we thought ultimately gave us the best chance to present our themes to the jury. That's what we tried to do, and that's how we used it. So a lot of demonstratives, we used demonstratives in the mock work to explore different ways to present the issues.
Did you do more than one mock? It sounded like you were saying you were experimenting with things. Did you do multiple mocks to try to?
We did two, and we did two, I would say, full-blown ones, and then there was other research that we did, but not at the level of a full-blown all day.
I gotcha. So did you find then that some of the stuff that you were doing, like you thought was going to be the main piece of evidence or a strong piece of evidence, when you found from the mock jurors where they just didn't care or didn't put as much weight into it as you initially thought, so that it caused you to kind of shift gears and go a different way?
Well, there was one thing in particular that was really pretty interesting. The answer is yes. And I think I can put it this way. Obviously, the accident facts, it was not reasonable to dispute. No one would dispute the fact that this 17-year-old young man had caused this accident. U-turn directly in front of a vehicle coming up behind it. I mean, there's really no debate about it. No one really challenged that. One of the things we learned in the mock, however, which was really confirmed by the jury outcome, was that the jurors in general were far less likely to blame the 17-year-old in causing the accident than they were the parents that allowed them to drive. These folks lived in Phoenix, Arizona, and they were on their way to Easter Sunday brunch at the grandmother's house in San Bernardino County, California. So they left at midnight from Phoenix to drive to their grandmother's house. The accident happened at 6:15 in the morning. They were about a half hour from grandma's house. The jurors, both in the mock exercise and our actual case, definitely had questions about the decision-making of the parents. The parents had left the day before. Kamaya had to work that night, so she couldn't leave until, later in the evening or the next day. And the plan always was that the 17-year-old was going to drive all night long through the desert under circumstances that he had never done before to get to grandma's house. That was a really interesting finding, and it turned out to be highly accurate in terms of the jury, the actual trial.
Yeah, that's always interesting.
Those are the kinds of things that happen in mock trials, don't they?
Yeah, and it's funny that's why you do them, because as I always say, it's better to find out then kind of the thoughts of the jurors than find out after, right? When maybe you get hit for a big verdict and then you talk to jurors afterwards and they're telling you all the bad things about the case or all the interesting things that you never thought about, after the fact is not when you want to find out about them, right?
Oh, that's for sure.
Jim, one of the things I found interesting while watching the trial proceedings is in closing is you didn't address damages. You didn't talk about damages, and you didn't even really offer up any alternative damages number. Is that a common practice that you have? Because I know this is one of those contentious things that people have different opinions on how to address damages.
Well, it's common and it's not common. In other words, I think it very much depends on a case. Big picture, if you're trying a case where you've either admitted liability or you've got it is reasonable to believe, more than just reasonable to believe, that there's probably going to be a liability verdict. I think and you would ask yourself the question, well, why are you trying the case? Well, you're probably trying the case because there is a significant disagreement on the value of the case from a verdict potential standpoint. That's a case where I will always anchor. I'll always have an alternative number. Whether it's a commercial case or a product liability case, I will always present an alternative, and it will be based upon evidence that we've developed at trial. In this particular case, we felt that we had a very good liability defense. Obviously, the plaintiff completely disagreed with this and thought they had a very strong case. But we spent a lot of time, Steve, on damages during the trial. There were issues about the extent of Kamaya's recovery, what her current status was. Her retained experts said one thing, but the medical records at the rehab institutes that she had treated at for quite a while said something different. So there was a lot of testimony about that kind of disparity between what the retained experts were saying and what the treaters were saying. And there was also a fair amount of extensive cross-examination that we did on the life care plan and some of the assumptions that were used. So there was evidence in the record that if the jury wanted to get into that, they could absolutely do it. But at the end of the day, there was a lot to cover on liability. And I just did not want to spend any of my time dealing with damages. So in this particular case, I just didn't do it. But I certainly have done it and would do it under the right circumstance. But I agree with you. It's definitely, you think long and hard before you do it. That's
yeah. Sure. Like I said, I definitely think that when we talk with attorneys, it's always do I or don't I? And sometimes, like you said, we suggest that there it's a zero. And I know for some attorneys, it causes a lot of stress and anxiety to say zero, or vice versa, right? Well, I want to say zero. And we're saying you probably better offer up something so at least they have an anchor number. So that's a good point that you bring up as far as it being a case by case basis and doing an analysis kind of when it works and when it doesn't.
Well, and in my own experience in jurors, this hasn't happened to me, but jurors have said, I've read and I'm aware of other cases where jurors, in explaining a very, very big number, will oftentimes be quoted as saying, well, that's what they asked for and nobody said otherwise. And so we thought that was probably reasonable.
Yep. I've seen that. I was just doing I was out doing a mock trial last week, and it's exactly what we heard from jurors is we didn't have anything else to go off of.
Right. Exactly. Exactly right.
So one of the other things I noticed about this case, this was one of those, it was a trial, post-COVID era, just recently. And I was kind of curious, what is that like doing a trial in California post-COVID?
Terrible. It was good and bad. What was terrible about it was that, first of all, the rules changed about halfway through the trial. But what was really terrible about it was the following. Number one, because of social distancing requirements, we had to do 4 separate voir dires. So because we could only put a panel of 15 people in the courtroom at one time. So we had to do 4 separate voir dires. Because of the court's schedule, we were limited in the number of days per week that we had to do this. Jury selection therefore extended over a month. And with each panel, we would qualify each panel for cause, dismiss them, and then move on to the next panel. Do the same thing, dismiss them, move on to until we finally built to the right number of jurors, which I think was, 27 or 28 jurors. And so it was a very extended process. Everybody was in a mask. So lawyers were in masks, jurors were in masks. They weren't even allowed to put their masks down so that you could see their face. So you have no facial recognition. And the easiest way I can say this is that I usually feel very connected during jury selection to the panel. I feel very connected in opening statement. I felt very disconnected in this experience. I didn't feel like I really was making the kind of connection with jurors in openings and in jury selection that I typically do. And that was a problem. Fortunately, they eliminated the mask requirement about a week into the trial. So for most of the proofs, we didn't have to wear masks when we were examining witnesses, and there was no masking for closing arguments. But jurors could still socially distance if they wanted to, and most of them did. So we had jurors spread out all over the courtroom.
That's what I thought, because obviously the way that the video shot, it was shot kind of right at you, right at the podium and stuff. But I could see you as you were talking, working a crowd, but I could see as you were drifting way off to the side. I assumed that there must have been jurors scattered all about.
We had TVs, we had a big TV back in the gallery, but for jurors that were way over on what would have been the left side of the courtroom, the TV was on the right side and there was another big screen up front. They struggled with documents that were shown on that screen. They would struggle with being able to see them. Eventually, for closing argument, the judge relented and made everybody move either into the box or on one side of the courtroom. That at least put everybody sort of in front of you, but again, spread out. But it's not, I've got a trial next month in West Virginia, and right now they're still under pretty strict COVID requirements. So as of right now, we're going to be facing the same kind of setup for that trial, which I hope changes by the time we start.
Yeah, I think to your point, right, being able to see jurors' faces and then being able to connect with them, right, is important to building rapport and getting, from a jury selection standpoint too, getting an understanding of how, they feel towards you and whether or not they're going to be good or bad jurors, right?
It was a challenge for sure.
Yeah. I want to switch gears a little bit. This case was involving a traumatic brain injury, and a lot of times, I work on traumatic brain injury cases. I'm sure you do plenty of them as well. And they're difficult types of cases, correct?
They are very difficult. Typically huge dollars involved from an exposure standpoint. The injuries themselves are very complex. The mechanism of injury, how this happens, very complex. In this case, there was a lot of medical evidence of serious injury. So that part of it wasn't part of our case, but I've tried brain injury cases where there was significant debate about whether and to what extent there was in fact a brain injury. So,
Right. And that's probably one of the most difficult parts of trying a traumatic brain injury case, right? Is that argument about whether or not there was a traumatic brain injury, the extent of the traumatic brain injury, what factors go into it, the Glasgow Coma score, all these different things that you have to get introduced, and kind of how subjective those things are, right? Those are all difficult aspects of a case.
Very, very difficult to deal with. And in this case, you had a situation where the plaintiff went to institutional daycare every day for a year. She was admitted to a program in Arizona. So she commuted from her home to this program for essentially 12 months. And then after that, she was full-time in the custody of her parents for a gap period, then up to trial of about 4 or 5 months. So there was a period of time where there was lots of information about her, And then there was a period of time, most recently, where there was not very much information about her, and except from the parents. So the parents telling the story during that period of time became a very important piece of the puzzle. So it was very challenging. It was very, very challenging to deal with, for sure.
And I think the other part that's challenging is you get the sympathy factor, right? Is you have this person who they have all the pictures of, look at how they were before, and then look how they are now. Their life's been destroyed. It'll never be the same. I think that's another aspect you have to deal with, right? Is just how sympathetic jurors are. Right.
And here you had a very beautiful young woman who was 21 years old at the time of the accident. She aspired to be a singer, a professional singer. She had actually released her own CD album. They played a number of clips from the album of her performing. She had video presentations that she had made. And the picture that she presented at trial was not this energetic, vivacious, very, very active, beautiful young woman, but it was someone who appeared to be, I would say, depressed, but even, much more than that. It was difficulty tracking questions, responding in a way that didn't seem to be completely to line up with the question that was asked. I mean, so there was they did a very effective job, the plaintiff's lawyers did, in presenting a very different image of Kamaya in the courtroom as opposed to the before picture. And as you said, that is difficult to deal with because it's sympathetic. And of course, in jury selection, I spent a lot of time on that. I mean, I preview that evidence and press people on how they feel about being able to listen to that, deal with it, be objective at the end. But no matter what people say in the jury selection, until they actually sit there and see it, it's a different story.
Yeah, and I think that's a good point. Did you harp on that, or at least mention many times kind of throughout the trial? I know a common tactic is to, during closings and openings, to talk about not letting sympathy and bias prejudice you. And that, did you have to really feel like you focused on that?
I do focus on that. I mean, in jury selection, Steve, I think we do. Our team does a really good job of identifying legitimate for cause challenges and exercising that opportunity. We had many cause challenges that were successfully argued and granted. And I think that is really important to jury selection in a case of this magnitude, because you only get a limited number of strikes, and you really need to be able to effectively challenge a lot of jurors for cause in order to ultimately get a jury that appears on its face to be objective and not predisposed. And even then, it's the luck of the draw to some extent.
Yeah. And I want to talk a little bit about jury selection because you've touched on it. What is your approach? You've talked a little bit about it, but what is your approach to jury selection as far as, your process and how you approach the whole issue and the process of jury selection?
Well, let me answer it this way. Number one, research. Mock trials are invaluable from my standpoint to really get a sense of what might be particularly helpful to the defense side. I mean, of course, if you're a defendant defending an automobile company, you would like to seat a panel of 12 people who love corporate America and think that most lawsuits are baseless and can't wait to get into the jury room to, quote, do the right thing. That never happens, and it's not going to happen. So you really need to work hard in mock research, mock trials, to develop profiles, pluses and minuses, what seems to be useful. But at the end of the day, subjectively, in the process itself, I look for people that have values, and they have lifestyles that would support a notion of right and wrong. I really big believer in that. I don't care so much about whether they're politically how people line up. It's more a matter of can they follow the rules when given an opportunity, regardless of what they may think about the rules. And again, easy to say, but really, really challenging to do when you're actually put to it. And so I look at jury selection as a process where you're attempting to put together a group of people that will work together. And honestly, a unifying group is something that's important to me. I mean, I try to look for people that I think are going to get along. I mean, again, in the world of what's important and what ultimately in jury selection, you're always looking at who's coming up next. So it's a choice between juror A or juror B or juror C. It's always comparative. It's always weighted. It's not, you're never making these decisions in the abstract. It's always situational, and it depends on what your alternatives are. And so you have to kind of keep that in mind. I think most trial lawyers that are good at this, I think they probably could have been air traffic controllers, because I think there's a certain amount of abstract kind of imagination that goes into this, where you're sort of keeping all the pieces to the puzzle up in the air and circulating. And ultimately the idea is to get, the case safely landed. So.
Yeah. And I think, and based upon what you're saying, I have a sense for how you would likely do your jury selection, but I think it's important for our listeners to understand, right? Is I'm assuming you're the type of person who's asking these open-ended questions, who's getting jurors to talk, versus asking the closed-ended question of who agrees, yes, no, and then move on.
Absolutely. I'm why do you think that? What do you think about that? Do you agree with juror number 5 and what they just said? You try to develop that conversation of people all engaging with one another, and lawyers that cross-examine jurors and ask them a bunch of leading questions, I find don't really find out very much helpful information. Open-ended questions, and of course, no script really. Listen to the answer that is given and use that answer in formulating your next question to that person or another person.
Yeah, I think that's an excellent point that you make, because I've seen too many attorneys who do voir dire very, very bad. And then, like you said, at the end of the day, you don't really get much of anything of information for your jurors. So I'm a very strong proponent as well, as ask questions, dig. And I think to your point, that's how you're able to find the information, right? The values and how they feel about certain things is you got to ask them and you got to get them to start talking.
And the other thing is that that helps you in a beginning to establish the rapport. I mean, I think you need to finish jury selection with some of the jurors either viewing you in a neutral way or kind of liking you and thinking that I don't mean this on an emotional level, but you just seem to be someone that is honest and straightforward and is not going to lead them down the garden path. And I think that's important. And I think you need to develop that rapport. And I don't think you do it by standing up there following a script and asking a bunch of loaded questions to which the answer is likely going to be totally predictable, but also completely unhelpful in terms of really doing what you're supposed to be doing.
And before I leave the jury selection topic, I think there's one more thing I want to touch on. Some people have their own opinions on this as well, but are you the type that says, these types of jurors are not good for us. These types of jurors are good for us. I don't want teachers. I don't want social workers, or do you use your gut feeling? Do you do any of that when you're doing your jury selection?
Well, I will say, and my mother was a teacher, and of course she has passed for a long time, but I always used to tell her when she was alive that I didn't want her in my jury and I didn't want any teacher on my jury. And of course she would argue with me, which is precisely why I didn't want her on. So, but teachers aside, I'd say there's no one really that I put in that category. And again, because, when the process starts, you don't really know where this is going to wind up. And I don't like to be saddled with a lot of preconceived ideas about how that particular person is never going to be helpful. We don't have enough time to go through the jury makeup in the Perry case, but I guarantee you this, without giving you any specific information, you watch some of the trial, and I don't know how much you know this, but of those 12 people, I believe that 8 or 9 of them were under the age of 30.
Interesting.
Okay. And the foreperson on that jury was a 19-year-old college freshman. And that was a 12-0 defense verdict.
That's very interesting.
Anyone that's listening to this that tries cases is now scratching their head and saying, So.
Yeah, no, I think that's interesting, right? Because we've heard the millennials catch a bad rap, right? Of being the ones, when you look at nuclear verdicts, it's the millennials. But
Correct.
Obviously that's not true from what you're saying.
Correct.
Yeah. Well, Jim, I'm going to wrap this up, but I got to ask the most important question. Michigan or Michigan State?
7 years in Ann Arbor, it's Michigan all the way.
Oh, this whole podcast is now falling apart. Well, I won't harass you too much. My wife is all my in-laws are all Michigan people, so you're in good company there at least. But
you got to root for Michigan, Steve. We're one of 2 Big Ten teams left in the tournament at this point.
I know, but it's hard for me. All right, Jim. Well, I appreciate you taking the time to come on the podcast. If anybody wants to get a hold of you, if they have questions, any additional questions, need to get a hold of you for any future cases, how do they get a hold of you?
Call my number. My cell phone number is 248-854-5070. jfeeney@dykama.com.
Excellent. Jim, once again, I appreciate you coming on, sharing your wisdom and experience and helping people hopefully learn to, get some defense verdicts going forward in the future. So this has been another edition of Litigation Psychology Podcast brought to you by Courtroom Sciences. We'll see you next time.